2. Loss of the thing due. Art 1262. An obligation which consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor, and before he has incurred in delay. When by law or stipulation, the obligor is liable even for fortuitous events, the loss of the thing does not extinguish the obligation, and he shall be responsible for damages. The same rule applies when the nature of the obligation requires the assumption of risk. Art 1263. In an obligation to deliver a generic thing, the loss or destruction of anything of the same kind does not extinguish the obligation. Art 1264. The courts shall determine whether, under the circumstances, the partial loss of the object of the obligation is so important as to extinguish the obligation. Art 1265. Whenever the thing is lost in the possession of the debtor, it shall be presumed that the loss was due to his fault, unless there is proof to the contrary, and without prejudice to the provisions of Article 1165. This presumption does not apply in case of earthquake, flood, storm, or other natural calamity. Art 1266. The debtor in obligations to due shall also be released when the prestation becomes legally or physically impossible without the fault of the obligor. Art 1267. When the service has become so difficult as to be manifestly beyond the contemplation of the parties, the obligor may also be released therefrom, in whole or in part. Art 1268. When the debt of a thing certain and determinate proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price, whatever may be the cause for the loss, unless the thing having been offered by him to the person who should receive it, the latter refused without justification to accept it. Notes: obligation is extinguished if the thing is determinate and it is lost or destroyed without the fault of the debtor and before the debtor has incurred in delay. When is loss presumed to be the fault of the debtor? When the thing lost was in possession of the debtor, unless there is proof to the contrary, and without prejudice to the provisions of Art 1165, i.e., thing lost through fortuitous event will still be compensated for if the obligor delays, or if the obligor promises the same thing to two or more obliges who do not have the same interest. In obligations to due, when the prestation becomes legally or physically without the fault of the debtor, obligation is not extinguished if the thing is determinate, and it is lost. The obligation is not extinguished, A1 by law or stipulation. The obligor is liable even for fortuitous events B when the nature of the obligation requires the assumption of risk. If the thing is generic, the loss or destruction of the same kind does not extinguish the obligation. If the debt of the thing certain and determinate proceeds from a criminal offense, the debtor shall not be exempted whatever the cause of the loss may be, unless the creditor refuses without just cause to accept it. Notes: courts will decide partial loss of an object. Courts will judge based on the circumstances and whether the obligation is so important as to extinguish the obligation. The court may consider the partial loss complete and extinguish the obligation. If it is complete, the rules under Art 1262 and 1263 must apply. In obligations to due, when the service has become difficult as to be beyond the contemplation of the parties, based on the doctrine of rebus sic stantibus, or where the parties stipulate in the light of certain prevailing conditions, and once these conditions cease to exist, the contract also ceases to exist. This is one case where the court can enter into the contract, by judging from the intention of the parties whether the obligation should be extinguished. Only in absolutely exceptional changes of circumstances that equity demands assistance for the debtor. Requisites. 1. The prestation has become so difficult to render. 2. And the service has become manifestly beyond the contemplation of the parties. Note, but difficulty alone does not excuse the debtor from fulfilling the prestation. This has been referred to as a subjective impossibility, where a promissor's duty is never discharged by the mere fact that the supervening events deprive him or her of the ability to perform. If they are not such to deprive other persons, likewise, of the ability to render such performance. Art 1269. The obligation having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may have against third persons by reason of the loss. Note, a provision for the protection of the creditor. Third persons may be insurance companies or guarantors.